Good morning, Judge Van Zyl.
Good morning, Chief Justice.
Are you well?
Yes, I am.
Yeah, a thought just dawned on me that you must have been wondering what's going on
Yes,
there.
it's been quite a wait.
Yes. Well, take your time and just tell us why you believe you are the right person for this position.
Chief Justice, I think I'm the right person for the position. I have the necessary experience. I've been a practicing lawyer for 35 years, of which 21 of those I've been a judge. I have acted in various courts. I've acted in the Labour Court. I've acted in the Labour Appeal Court. I have also acted in the Supreme Court of Appeal. I have, over the 21 years, I've been, for 5 years, I've been in the Transkei Court at the time, thereafter in the Judicial Court. After the integration of the 4 courts, we have all been appointed also as judges of all of the other courts, which meant that it took me to Grahamstown. It also took me to Port Elizabeth. So as far as the required experience is concerned, I believe that I'm qualified to occupy the position. I've also been acting as Deputy Judge President in Bisho. In fact, my first acting appointment as, well, at that time as was Judge President was, I think, in the year 2000 in Mthatha in the Transkei. I was thereafter appointed, I think, in 2003, if I'm not mistaken, 2013, if I'm not mistaken, as acting Deputy Judge President of the Bisho Court. And in March of last year, I was permanently appointed. I have, during the time of my acting appointment as Deputy Judge President, and also as Deputy Judge President of the Bisho Court, I have implemented certain measures in order to speed up the finalization of matters, both civil and criminal matters. I can give you more details of that if you require me to, which has been successful. I have also made use of the time to build relationships with the court staff to make sure that the court is properly staffed and capacitated in order to enable the judges to perform their functions. It is an ongoing process. We do have, like all the other courts, I would assume, have staff shortages due to financial constraints, but we are doing well as far as I'm concerned. The finalization rate of our cases, both civil and criminal, have increased drastically, and so from that point of view, I've had success. I also, because of the years of having been a judge, I have built up relationships with colleagues. I'm known to my colleagues. I think I've earned the respect and the trust of my colleagues to lead them in the division. So shortly or briefly, for those reasons, I would say that I feel that I'm qualified to hold the position.
What is your vision for the division?
My vision for the division, if I can put it in one simple sentence, is the following: is to have a transformed division consisting of a bench that is professional and whose aim it is to effectively and efficiently dispense justice, thereby giving content to the right to access to justice. That to me, in essence, is my vision which I have for the division. I can tell you how I intend to achieve that vision. If I can break it down, the first aspect thereof, a transformed division, we are all aware of the instruction that we get from Section 174, subsection 2 of the Constitution, that the bench must reflect the gender and the racial makeup of our country. In order to achieve that, I am of the view that we should have a more focused approach to the appointment of acting judges, because from the ranks of those acting judges, the permanent judges are appointed. In the past, I've had the feeling that judges were appointed as a last-minute measure to come and act, and I do not think that we have achieved the objective of ensuring that the right persons were appointed as acting judges, and those are the people that eventually come before you as the Judicial Services Commission for permanent appointment, and on numerous occasions no appointments were made. So it will have to be a more focused approach, and in going about achieving that, I would need to consult widely. I think there need to be closer cooperation between the judge president and judges of the division to extract their views with regard to acting appointments. They are, after all, the people before whom attorneys and advocates, practitioners appear on a daily basis, who are best placed in order to comment on the suitability of candidates. One further will have to make contact with the profession, the different professions, the advocates' profession as well as the attorneys' profession, in order to firstly inquire as to who would be prepared to make themselves available, and then have some other system in order in which to assess those who are prepared and to move forward from there. The same applies with regard to the academic institutions. We have in the past had a number of judges who were appointed from the ranks of the academics. I'm thinking of Judge Tlotlo, who was a colleague of mine at the Bisho Court, who is now retired, who came from an academic background. And people with an academic background bring or add to the jurisprudence and to the makeup of the court. So the focus, as I say, is to identify suitable candidates and to build up a pool of candidates from which to then choose acting judges in order to ensure that transformation remains or is and remains a reality. Transformation also includes another aspect, in the sense that one has to look at the makeup of each of the courts. As you're aware, we have 4 courts in the Eastern Cape for historical reasons. Those courts are separately staffed with their own judges, and it is important to have a good balance of experience and, if I can refer to inexperience. Judges who are appointed, we know what the challenges are with regard to transformation, and very often we have to appoint judges who have the potential to grow, whom we have identified to have the potential to grow. And the challenge is then to have a good balance between those judges and more senior judges in the separate, in the individual courts. The second aspect of the vision that I've referred to is the professionality of the bench.
I missed the word, what of the bench?
The professionality of the bench, yes. We have a total different situation from what it used to be in the past. As I've mentioned at my previous interview, where judges were required in the past to simply resolve disputes between individuals. Their functions have now been extended. It's to apply the Constitution, to give content to the Constitution, to give effect to the rights in the Constitution, to provide a check on the exercise of public power, and to rule on the constitutionality of legislation. So the functions of judges have become more complex, require more skills from them, and one has to ensure that the judges are properly skilled. In order to achieve that, one needs to assess the needs of each court with regard to this aspect, and where there is a need, to ensure that proper training or instruction is given, making use of the facilities that are available to us, namely the Judicial Education Institute. So that is to ensure that judges are capacitated and that they are resourced to perform their functions efficiently and effectively. And as I've said, is to provide training and identify shortcomings and to deal with those shortcomings where they exist. We have been given tools now by the Office of the Chief Justice with regard to the keeping of statistics, which is beneficial in the sense that one can identify where some judges are maybe struggling, where it takes them longer to finalize certain cases, which may require further investigation and may very well turn out to be a case that the judge lacks the necessary experience in certain fields. Again, it comes back to the issue of transformation. We know that we appoint judges are not only appointed from the ranks of the advocates any longer, they're appointed from the ranks of attorneys and also from the academic institutions. The result is that you will find that, and the magistrates, of course. Let's use a magistrate as an example. One may find that a magistrate's most of his or her experience lies in doing criminal work. There might be a need to improve the skills of that particular judge with regard to civil work, and even with advocates. You'll find that some advocates come to the bench, they've never had a criminal practice, or they just had a criminal practice. So those are issues that need to be identified, and it needs to be addressed. Practical example of that at present is with the case management process, which is being followed in the Bishop Court and in the East London Court, which has been introduced there for the last few years, is that it's quite apparent that most of the cases, and that applies to basically the whole division, is that most of the civil cases that we do are personal injury claims, either claims against the Road Accident Fund or claims against the Department of Health for medical negligence. In order to do case management efficiently, a judge needs to know exactly what the claim is all about. And if you have difficulty in dealing with damages claims, then it makes it more difficult to effectively and efficiently do and partake in the case management process. So there are shortcomings from that point of view that I have identified, and should I be appointed, that is one of the aspects that I would like to address with the assistance of the Judicial Training Institute in order to assist with case management. The other aspect is case management itself. It's a total different process from what most lawyers are used to. Most lawyers have grown up and in the adversarial frame of mind, namely that litigation is driven by the plaintiff, and where there's almost a slavery to the rules and the rules of court, and where the rules of court are sometimes used for technical, to gain technical advantages in order to slow the process down or to speed the process up, or simply to achieve what is not conducive to the efficient and speedy finalization of cases. So with case management itself, I think there is a need for further training insofar as the judges are concerned. In the last aspect, insofar as the vision is concerned, is that of the efficient and effective performance of the functions of the judicial officers in the court. And that's not only the judicial officers, the judges, it's also the court staff itself. Important thing to start off is to instill a work ethic. That is important. It's important insofar as the court support staff is concerned. It's something which I have done in Bisho by instilling a work ethic, and to do it on a voluntary basis. It's not, in my view, conducive to use your office in order to extract a strict work ethic from staff. It's by motivation it can be achieved. So that is the first thing, instilling a work ethic, to lead by example, and as I've said before, something that I pride myself in is my own work ethic. And if you seem to work hard, others would follow suit. I've mentioned earlier is to build relationships in this context with support staff, to instill in them a sense of belonging to the court, to appreciate their own function within the court and the importance of their own function, and thereby creating a pride in your work. And if there's a pride in your work, it also transforms into a good work ethic. The other aspect under this heading is to transform the manner in which cases are made ready for trial. I've alluded to the issue of case management with regard to civil cases. I've also introduced that with regard to criminal cases, and I think it's something that can be implemented right throughout the province. It has achieved results. It requires a lot more work from the heads of the individual courts, but it does show results, especially in those courts where there are a backlog insofar as criminal work is concerned, and where there is a difficulty with partly heard matters. It is the most efficient and effective way in dealing with that problem. Another aspect is to identify blockages by monitoring and court performance, and to take remedial action where required. Now that basically means that the statistics which are being supplied on a monthly basis need to be analyzed. I have in Bisho on a weekly basis been monitoring court performances, that I know what is happening in each court. And I think that is something that can also be rolled out into the rest of the division. You can immediately, in a very short period of time, identify problems, the reasons for for those problems, and then take the necessary remedial action. Another aspect under this heading is a reassessment of the needs of each of the 4 courts in the Eastern Cape. The way the courts are being set up, the number of sittings per court, the way in which the courts are allocated, the number of courts allocated for civil, number of courts allocated towards criminal cases have basically remained the same for the last 15, 20 years. And there hasn't been a reassessment of that. And I think with the assistance of the statistics that we do have and with case management that we are doing, there should be a reassessment, and it is necessary in the sense that we have a shortage of judges. I think it's known that the workload has increased in all of the courts. The workload has increased, and the number of judges hasn't kept up with the workload. So one will have to find ways in order to deal with that. And I'm certain if one has a very close look at certain of the courts, some of the courts could be collapsed into one court, which will free a judge up to do cases where there is a particular problem, whether it's a backlog with regard to criminal cases or whatever the problem is. A further aspect that I think that needs to be attended to is the delegation of functions. It cannot be expected of the head of the court, the judge president, to be everywhere. He's very reliant on the heads of the respective courts, and in order for him or for her to efficiently perform their functions, there need to be a delegation of functions, something which hasn't happened. It has created how can I describe it, as a bit of a grey area, uncertainty as to what exactly is expected of the different heads of courts. I think that need to be spelled out, and the functions which are delegated are those which would assist and enable the judge president to properly perform his functions, to plan the roles, and to deploy and allocate judges where the need arises. I've alluded already to the shortage that we have with regard to the number of judges in certain of the courts. I think that is something that needs to be pursued, and hopefully one can engage the ministry with regard to that aspect. And another aspect where the ministry does come in is the jurisdictional conundrum that we still find ourselves in, that after 20 years we effectively still sit with the jurisdictional areas as they were determined in the previous dispensation. We basically have Bisho and Tata still have the old homeland jurisdictional areas. It's something that needs to be addressed, and whoever is appointed as judge president, I would strongly urge him or her to engage the ministry with regard to that. Thank you, Chief Justice.
Acting Judge President.
Thank you, CJ.
Mic doesn't seem to be on. Is it?
Thank you, CJ. It's on now. DJP Van Zyl, what South Africa must know concerning the Eastern Cape is this. We have a problem with applying case flow management across the board. And if this is left unresolved, a lot of what is referred to as visions of the JP can never be achieved. If you are appointed JP, how would you ensure that case flow management is implemented in the PE and Grahamstown stations in the same way that it is implemented elsewhere, in particular your court that is in Bisho and Mthatha?
Yes, JP, the thing is, one needs to. It's a product that you need to sell. That's the long and the short of it. Because those who are affected directly by it, and without whose cooperation you won't be able to do it effectively, is that of the practitioners. I would do exactly what I have done in Bisho and East London, and that is to sell the idea to the practitioners. The way in which I've done that is to place the emphasis on the benefits of the introduction of case management. There is the perception that case management is taking work away from attorneys and advocates. It may be true for the latter to some extent, but not insofar as the attorney's profession is concerned. And once they partake in case management and they see the benefits thereof, they are quite willing to participate in it. So what I have done is basically to sell it on the basis that we will save time, I will save you costs, and I will get your case on the roll very quick, far quicker than it is happening at the moment. And that is effectively what each attorney wants. And each attorney is under pressure from his client to get his case before the court and have it finalized as soon as possible. The other benefit, of course, is, and that goes with the fact that cases are finalized more quicker, is that many more matters now end up in settlement, which is an added benefit to bringing the matter to finalization and putting the money in the pocket of the client, so to speak. So it's simply, as far as I'm concerned, a case of selling the idea and selling the concept to those who are directly affected by it and those with whose cooperation you cannot practically implement it effectively. You're probably aware, you've also acted as DJP in Bisho for a while, the benefits that it has shown. And attorneys which initially have not been in favor of it, those attorneys are now actually the ones who are actively participating and even making suggestions as to how it can be improved. So it's getting past the hurdle of selling it to the practitioners. Besides that, the only other issue that to me that remains is getting uniformity throughout the division, that we have the same practice, that if an attorney goes to the Bisho High Court, he knows what to expect. It will be exactly the same practice which is being followed in Port Elizabeth or elsewhere.
As you do know, the drawing up of the role, the division role, has been one of the biggest challenges. We discussed, and you and I discussed it, and we did everything possible to ease it up until we landed somewhere. But what did remain is the whole question of the outstanding, that is part head matters, be it a matter emanating from a civil court or from a criminal court. But those outstanding matters have this problem of making it impossible, or rather difficult, not impossible, I'm going to say difficult, for the JP to draw up a balanced role, given that when you allocate duties, one has to adhere to the principle of fairness. If you are appointed JP, how would you resolve this?
Yeah. JP, what I would do is I've referred earlier to the delegation of functions to the different heads of court. As far as I'm concerned, the person who's the best placed in order to assess the way forward for a partly heard matter is the head of that court. It's not the judge president who sits in Grahamstown who is in a position to decide how that matter is to be finalized. He needs to act on the advice of the head of the specific court. What needs to be done is that with each and every matter which become partly heard should not be postponed without the permission of the Deputy Judge President of that particular court, who will make an assessment of where the case is. In other words, what still needs to be done. Are we busy with the state's case? Are we busy with the defense case? How long is the trial likely to last? And how many days are required in order to finalize the matter? If the matter turns out to be a case, and let me just step back a little bit, that is assessed, should be assessed by the Deputy Judge President in consultation with the parties involved, with the prosecutor and with the defense counsel or the defense attorney to assess that. Then to take it forward is then, if the case requires a number of days, is then for it to be allocated a date. Being on the roll, it's in the interest of everyone that that case be finalized as soon as possible. There's nothing worse for a judge to sit with a case that gets rolled over for months. By the time you get the case comes before you again, you've forgotten what the case is all about. You have to have the record typed. You have to go and read your notes, which half of the time you can't read your own handwriting. And it's in everybody's interest that cases which are on the roll should be finalized as soon as possible. So that case should then be placed on the roll for the next term, and the JP should be informed accordingly. There are other categories of cases, and I feel very strongly about this, where one witness may be outstanding, or it may be a case of argument and judgment being outstanding. Those cases, as far as I'm concerned, do not require to take up more time on the roll in the following term. Inevitably, those are the type of cases which end up pushing other new cases which have been placed on the roll, pushing them out of the roll and causing a delay in the finalization of those matters. Those matters are to be dealt with by the judges in their own time and by providing a plan as to how those matters are to be finalized. And I would expect the judge to make a suggestion to the Deputy Judge President as how he or she intends to finalize that matter and when. And I suggest that the opportune time to do that would be during recess. We have in total 3 months of recess in a year. If a judge takes 4 weeks out of that 3 months, he still has 2 months in which to do whatever he or she needs to do. I don't think that is a big sacrifice of anyone, and normally these cases require a day, mostly maybe another 2 days. So by dealing with it on that basis, I would think that the problem that you're alluding to should be resolved.
Mr. J, thank you very much. Those are my questions.
Thank you, AJP. Premier?
Thank you very much, Chief Justice. Good day.
Good day, Mr. Premier.
Just 2 quick ones. In your earlier submission, you did refer to sometimes the need to consider, in terms of transformation, having into the bench appointed judges with potential. You did raise that. I just want to check, in your experience, if you haven't come across where such tended to be to the detriment of the proper provision of justice.
Yes, Mr. Premier. Look, most of the judges which have been identified on the basis that they have shown potential to grow have lived up to the expectation. There might be the odd one who hasn't, and who's been it's been a disappointment, but it's also something that can be resolved. And the way to resolve it is to identify those judges and to give them the proper support, whether it's by way of training, provide extra training, or another way is to ensure that those judges are placed with senior judges. I'm thinking of appeals, for instance. We do full bench appeals and other appeals in the division, to place those judges with more senior judges and for them to work with them. And to have an informal mentorship by making one or two more senior judges responsible for that judge. But again, one has to build a relationship with that judge. You have to, without insulting him or her, indicate that we think that you do need support, and this is what is being suggested. So I think with the necessary support, that issue can be resolved. The thing is, we have to transform the bench, and we do not always have practitioners who have the required experience, whether it's because of adverse briefing patterns or whatever the case may be. But people need to be identified on potential, and then be taken forward with the necessary support.
No, thank you. You then brought the other matter I thought I was going to get to, that of seniority among the judges. Would you, and I don't know how much premium you attach to this, in respect of this notion that there tends to be this hierarchical relationship born out of the reality and perception of seniority. In respect of this at leadership levels, don't you think this could be or is sometimes a constraint, or would you say that support is something that could still take us through even when leadership is at issue in this respect?
Yes, I don't think the hierarchical issue is such a big issue. If you have in mind by referring to that as simply by reason of seniority, a person should be appointed in a certain position. I don't think that is the case anymore. That is something that came from the old system where judges were appointed from the ranks of the advocates, and judges were senior advocates, in other words, silks, and they had to be silks of a standing of a certain number of years when they were appointed, and judges were very particular about seniority. I think we've made a break from that. The simple fact that we're now appointing magistrates and attorneys and academics to be judges, that doesn't really apply anymore. I think the issue more is whether or not the person has the necessary experience and has the necessary qualities in order to fulfill that position. Look, one has to be careful. You're requiring a person, if you appoint him as a judge president, you require him to give instruction to other judges, and in that context, it may create difficulties, but I don't think it's that much of a big issue.
No, thank you very much, JP.
Thank you, Premier. Judge President Lope.
Thank you very much, Chief Justice. Judge Van Zyl, I have two questions for you. The first is this. There are only two of you. Sorry. There is one position of a head of court which has been advertised. If this commission were to recommend you for the position of a judge president, will you be in a position to embrace the loser and work closely with him, reach out to him, and not feel that he was arrogant in the first place? We've had instances where a successful candidate looks down upon the loser instead of working together and harmonizing the division in the interest of service delivery. Then you end up with personality. So the question is, will you embrace the loser if you were successful today and work together with him? That's the first question.
Yes, definitely, Judge President Slope. I don't have any difficulty in working with what you refer to as the loser. The other candidate and I have a long relationship and a long friendship. It comes from Mthatha days when we were still at the bar. We're very well known to each other. And at the end of the day, I've taken an oath to uphold the Constitution and to perform my functions in accordance with the Constitution and in a professional manner, and in such a way as to act in the interest of the division as a whole and in the public interest. I mean, that is what we are there for. We're delivering a service to the public, and if there's a hindrance like that, then I would be failing in my duties and my functions.
That. The other question relates to transformation. Section 174 of the Constitution provides that when recommending candidates for judicial appointments, regard must be had to transformation with specific reference to race and gender. Now, where you have two candidates, both equally competent, they both do well at an interview, right? One of them is a male candidate, is a white male candidate, and the other one is a candidate from a historically disadvantaged background. In your opinion, what does transformation dictate in a situation like that?
Well, Judge President Slope, transformation has a number of aspects to it. The first, as you mentioned, we have the instruction in section 1742 of the Constitution to have a judiciary that reflects the racial and gender composition of our society. And that instruction is there because of what we've inherited in 1994. What we got in 1994 was an untransformed bench, which basically consisted of white males and no female judges. So the Constitution looks backwards. It looks to what the position is and how to address that issue. And it is an aspect which, as I've indicated earlier, that continuously need to be addressed. It doesn't mean that because we've appointed a few black judges, that is now the end of the matter. Judges come and go, they retire, and new appointments need to be made. So it's something that needs to be kept in mind all the time. But I would also say that transformation has other facets to it, and the first is that the transformation of the bench speaks to the bench itself, but the Constitution also speaks to the transformation of the courts. And the reason why it does that is in order to give effect to the right of access to justice, that right which is entrenched in the Constitution. And in order to give effect thereto, one needs to have effective leadership, and whoever is appointed would require the necessary skills and experience. So that needs to be considered as far as the transformation of the courts are concerned. But there's also another aspect to it, and that is that the Constitution doesn't only speak towards the past, it also speaks to the future. And what it does say to us is the following. What it envisages is the establishment of a non-racial, non-sexist and equal society founded on human rights. That is what we are aiming for. And I believe that within that lies the question of diversity, is what will my appointment bring to the bench? Not only my experience, my leadership skills, and my ability to what I believe I can do for the division in order to take the division forward, but also in order to ensure that there is diversity insofar as the bench is concerned. One needs to consider in this context as well is that we're not talking here about an ordinary judge's position. I'm not here to be appointed as a judge. I've already been appointed a judge. We're talking here about being appointed as a judge president of the court. The question is, to what extent have the ranks of the judges precedent been transformed? And one needs to assess the appointment, whichever appointment is going to be made, also in that context. If you say to me that you have too many white judges precedent, then so be it. But is there space for diversity in the ranks of the judges precedent? And if there is, then I would submit to you that nothing stands in the way of my appointment as to the position.
Thank you, JP. Deputy Minister?
Thanks. I mean, just look, it wasn't one of the questions, but an obvious response to what you've said. Yes, there might not be an issue with judges president, but with, in terms of the stats we've got, 15 of the 27 Eastern Cape judges are white. So that's a problem. But look, the question I wanted to ask really was your vision for the magistracy. What would you plan to do as judge president if you were appointed? And what have you been doing as deputy judge president in your area of the province to improve the judicial functioning of the magistrates' courts?
Yes, I have introduced what we refer to as a stakeholder meeting twice a year, effectively to iron out difficulties with regard to criminal matters, because we are being fed criminal cases from the magistrates' courts. We're also being fed with appeals from those courts. And at those stakeholders meetings, that includes the magistrates, in order to find out what their difficulties are, if they have any difficulties, and how they suggest that those difficulties can be resolved. The whole idea is to ensure that that cases are, right from the beginning, when it appears in the magistrate's court, that the necessary things are done, ensure that accused persons have the necessary legal representation, that those issues are not dealt with only at the stage when the matter comes to the High Court. So those are issues that is addressed, and that is what I have implemented insofar as what my position as Deputy Judge President allow me to do. Insofar as the magistracy in the province as a whole is concerned, that is something that vests ultimately in the office of the Judge President, which then raises the question, what do I intend doing? Closer cooperation between the High Courts and the magistrates' courts. As I've indicated, we are being served by them, in the sense that cases do come from them to be heard in our courts. It also, their finalization rate of their cases has an impact generally on the delivery of justice in the province as a whole. So as much as we try to improve the delivery of justice in the high courts, the same applies insofar as the magistrates' courts are concerned, and we need to look at them and see how we can address those issues. If any issues do exist, and how to deal with that. So I would say it's closer cooperation, closer contact between the judge president and the magistracy. I think in terms of the Superior Court's bill, I'm not too certain. I think so. The judge president also has an oversight function insofar as the magistrates are concerned, and that needs to be formalized, and it needs to be on a practical level. It needs to be implemented. I don't believe that the PEEC meetings that we have every other term serves that purpose. There are too many, the simple reason being there are too many other role players involved, and with the result that what you need to address insofar as the courts are concerned get caught up in issues with regard to maintenance, with regard to problems that the police have and problems that the prisons have, and that sort of thing. So I think there is definitely a need for another forum, if you want to call it, where the oversight function, which is supposed to exist, that is properly carried out.
Maybe if I can just interrupt you, it's more than an oversight function. In terms of the Act, it's responsibility for the coordination of the judicial functions of all the magistrates' courts.
Yes.
I would see that as more than, and I'm
More
sure you'd agree, more than an oversight function.
Yes, I agree with you.
Commissioner Msomi?
Thank you so much, CJ. Judge Van Zyl, you were here in April, and obviously you did not make it. You have come back now to this round of interviews. What interests you most about this position, that notwithstanding the fact that you did not make it in April, you have come back here? What is it? You say you want to make a contribution. In very, very short terms, what contribution do you really want to make?
Contribution, Mr. Commissioner, you probably gathered from what I've said so far, I'm a very practical person, and to me, the most important thing as far as our function is concerned is the delivery of justice. Because if you deliver justice efficiently and effectively, it means that you make a door open for more cases to be heard, and for people to really enjoy the right, or to have access to the right of access to justice. And I believe there's a lot to be done in my division. I think we've been, without wanting to criticize anyone, I think we've been treading water for too long, and I think that we need, on a practical level, things need to be implemented and need to be improved. And I think that with my skills, my experience, that I can make a difference as far as that is concerned.
Thanks for that answer. I asked this question because when we obviously shortlist candidates, various inputs are made by various bodies. And one of the bodies that has made an input about your suitability or otherwise of this position is the Law Teachers Association. And this is what they have to say about you. His contribution, Judge Van Zyl, to the transformation of the judiciary is not explicit within the context of providing access to justice to those who come from previously disadvantaged backgrounds and transformation of the judiciary in the context of those who are appointed to the positions within the judiciary. They go on to say they have not seen a meaningful role that you have played in mentoring qualified candidates and upcoming lawyers or judges from previously disadvantaged backgrounds.
Yes.
What do you have to say
Yes.
in response to this statement which says, if you appoint this candidate, he has led the leadership position, but no contribution to the broader transformation agenda?
Yes, there are two statements in there. The first is the issue of transformation. There is no factual basis provided for that statement. I do not know on what it is based, but it's not correct. I have, in the time that I've acted as JP the year before, and you can, at the previous interview that was raised by one of the commissioners, I think it was Mr. Nochesi, the people that I have appointed or had appointed as acting judges during that period, and the same applies to the Bishop High Court. The people that I've recommended to the Judge President to appoint, and the ones who he had appointed on my recommendation, were either women, most of them were women, and were black women. So there is no factual basis for that statement. Is not provided, and I urge you that it's incorrect. You have the AJP here, and he can indicate to you as to what my request was to him as to who should be appointed in my place in the recent past. The second statement relates to mentoring. Now, mentoring happens either on a formal or an informal basis. Again, I do not know where on what basis, factual basis, that comment is made. Mentoring is either on an informal or a formal basis. My approach is to mentor, to make use of every opportunity that I get to pass on knowledge and skills. I can assure you that within the case management setup, whether it's in the criminal setup where I meet with the practitioners, and even in the civil setup, where I would go through the elements of the crime, and I would take time in order to explain the legal position, what needs to be proved, and how the case needs to be taken forward, what the implications of a defense is, and how it is to be dealt with. Small examples of how it's done on an informal basis. On a more formal basis, I have taken personal responsibility for each acting judge which is acted in my court. And you can speak to the acting judges. I have put them on a practical level. I have on a weekly and even sometimes on a daily basis inquire as to what progress they're making with their cases, how they're faring, if they need any assistance, and I have assisted most of them with their work on a practical level. I have put those acting judges with me on appeals where I sit with them in order to use that as an opportunity to pass on knowledge and skills to them. I have, on a formal basis again, organized workshops for public prosecutors, attorneys, and legal aid practitioners with regard to criminal cases, the practical day-to-day running of criminal cases, in order to address problems that we were having in the finalization of matters. And I've done that with the assistance of more senior and experienced judges. I've done the same with regard to civil work, which is on an introductory level, and which is something that I still intend to carry out further. And this is something that can, in a position of Judge President, can be taken further with the assistance of either more experienced judges, or ideally to make use of retired judges. the same applies to, as I've mentioned earlier, with the identifying process with regard to potential appointments as acting judges. So, those statements are incorrect.
Thanks, Judge Van Zyl. Just to take up the question that was raised by J.P. Hlope about you, he used the word loser, embracing the loser. If you were turned out to be the loser today, would you embrace the winner?
My answer will be the same, Mr. Commissioner.
And lastly, from me, two candidates on paper, they appear to be good. Why you? Why should we look at you, not Menenge? Thank you.
I would say simply by reason of my experience as a judge, my experience as a judge in a leadership position, where I have proved myself to have made a difference to the running of the court, and with great success, that would submit to you that I'm better placed than the other candidate, insofar as that is concerned.
Commissioner Nkosi Thomas.
Thank you. Let me use the other mic. Thank you, Chief Justice. And good afternoon to you, Judge.
Good afternoon, Commissioner.
My question has been taken care of in part by both J.P. Hlope and the Deputy Minister, as well as the Commissioner over there. But I just want you to assist me with reference now to the statistics that have been harvested by the Office of the Chief Justice. In terms thereof, more than 50% of the judges in that division are white. Now, how would your appointment be in furtherance of the provisions of Section 174.2? Thank you.
Yes, my answer to that is, and I think I've alluded to that before, is that I'm not here for a judge's position. I'm here for the JP's position. So it's not simply a case of appointing another white judge. I'm already a judge in that division. I'm one of the white judges that you're referring to. The question is, what can I bring insofar as diversity is concerned to the ranks of the judges precedent?
Thank you, Chief Justice.
Thank you, Commissioner Nkosi Thomas. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge Van Zyl.
Good afternoon, Mr. Singh.
Two of my questions have been asked by Commissioner Msomi, I think because we both come from Durban. But anyway, I have two further questions. The one question is, Judge Van Zyl, you have been acting Judge President before, as your CV indicates. You have acted as Deputy Judge President, and you were appointed as Deputy Judge President. Now, you have said to the Commission that there are certain measures that you would like to bring about if you are appointed as Judge President. What I'd like to know, in your capacity in those positions I've mentioned, have you ever tried to influence decisions or change so that those measures can be brought about? That's the first question.
Yes, I have. On various occasions in meetings that we've had, because most of those issues relate to practical matters, and it's to a large extent to do with the deployment of judges. You must understand that after '94 there were 4 courts, they were untransformed, and they were 4 separate courts. The initial idea was, and the first Judge President Somyalo that was appointed after '94, which his priority was to integrate the courts. In other words, to create one division out of effectively three divisions, separate divisions that existed before. And the way in which he went about that was in order to deploy judges from the different courts, from one court to another court, and that is what he did, and it worked. It created a unified division. What has happened in the meantime is that the bench has become transformed to an extent. We can still improve, as was pointed out by one of the commissioners. The makeup of the bench has changed. Practitioners are now appointed from Umtata to Bishop, or practitioner from Port Elizabeth is appointed to Grahamstown or to Umtata. It's not a case of judges in those divisions are the judges who were there when unification happened in '94. So the need for that has somewhat disappeared. The problem that it has created in the last few years is that it's created difficulties with regard to partly heard matters, aspect that the acting judge president has alluded to, that judges were deployed to other courts to do criminal work, for instance, ending up with a matter which becomes partly heard. And for that judge then to return from Port Elizabeth or wherever he is back to Umtata for that matter to be finalized. It resulted in a delay in the finalization of matters. It has resulted in new cases not being able to start, and it simply has created a whole number of practical issues. So those are issues that we have addressed for reasons that the previous judge president saw fit. He continued with that pattern of deploying people. The AJP and I have discussed it, and we have, with the last two terms, we've changed that. We've now keeping judges more in their courts and deploy them where there's a necessity, and also deploy them on a basis that the judge would not walk away from a court with a partly heard matter. So those are practical issues that I think that need to be changed, which we haven't been able to do before.
So the rotation of judges would not be something on your mind if you are appointed?
It will, but it will be on a practical level. A judge, there's no need for a judge in Umtata to go and do a criminal case in Port Elizabeth. Criminal cases, and also civil cases for that matter, have got the tendency to become partly heard, especially if they're not properly managed insofar as their set down on the roll is concerned. They become partly heard, and it creates an issue. But there's nothing stopping a judge from Umtata to go and do civil duty, motion court duty, in Port Elizabeth. Because when he walks away there on the Friday, he may walk away with a few files in which he has to write judgments, but he doesn't have to come back again. So there is still that need, and I think we should carry on with that, but it should be on a more pragmatic basis.
And then, Judge Van Zyl, if you are appointed, would you consider yourself being a person who would move from court to court and actually sitting and listening to cases and penning judgments? Or do you think your administrative and other duties would be too much for you to be able to do that?
Mr. Singh, I think my initial function would be to make an assessment of each of the courts. From Bishop, I know what's happening at the Bishop Court, but there will have to be an assessment of the other three courts in order to implement case management, and in order to as I've said earlier, I think that some courts could be utilized, or some judges could be utilized more effectively elsewhere. Do away with some courts and place them doing in criminal courts or whatever the case, where there's a need. So in order to make that assessment, initially I think it will need the judge president to move around to each of those courts and to sit and meet with the different role players. Insofar as crime is concerned, there will have to be close interaction, and that to me is something that is lacking in the other courts, close interaction with the Director of Public Prosecutions. Cases should be set down in consultation with the head of that court. So it will require the staff, as I've indicated to you. To me, cooperation of the staff is essential for the effective running of the courts. And then the different role players, the practitioners, as well as the Director of Public Prosecutions, who to me is the most important person, because the clogging up of the rolls, the delays that we have, inevitably happens in criminal matters. So it will require at least a year or 2 years of going around to the different courts and be there in order to assess the situation and see what remedial action is required, if any, and then to visit the courts on a regular basis. The judge president, as far as I'm concerned, as I've earlier indicated to you, to me, work ethic is an important thing, and one must be seen to work hard in order to inspire others to do exactly the same. The judge president should sit in court, he should hear cases, he should sit in appeals, and he should sit in those other courts and be there to sit with the other judges. So it's not only a case of sitting in Grahamstown in an office. No.
My last question, Chief Justice, to Judge Van Zyl. We've heard this interesting terminology, and for those of us who didn't do Latin, dies non. To what extent is it a problem in your division? And if it is a problem, what can be done about it?
I suspect you're referring to the first day of term.
On Fridays, people tend not to want to work the entire day, and there's a lackadaisical sort of attitude on a Friday. If I'm correct, Chief Justice?
Well, it's definitely not an official day, is none, that's for sure. Well, that shouldn't be the case. I mean, the court sits until 4 o'clock or 4:30 on a Friday, and judges should be there as long as they're required to be. One can plan your court in such a way that you can get away early on a Friday if you need to, but you will have to do your work in order to be able to do that. But there's no official or unofficial days, none on a Friday, as far as I'm concerned.
But what is the current state of play from your experience and being there for a number of years about Fridays? Thank you.
Mr. Singh, I can only speak for my own court. I don't come in the other court, so I can't say who's there on a Friday and who's not. My court, it's not an issue. That I can assure you. I suspect that it may very well have something to do with judges who were appointed in certain courts and they don't actually reside in the area of that court. That to me, that you might have gathered that from previous sittings where I participated in a sitting, is a bone of contention, because you do have complaints that judges have to leave early because they have to get home and they have a long way to go. Judges should be appointed to a division, they're appointed to that, or to a court, they're appointed to that court, and they should preferably be there.
Thank you, Chief Justice.
Commissioner Norman.
Thank you, Chief Justice. Good afternoon, DJP.
Good afternoon,
Yeah.
Advocate Norman.
Thank you. I just want to inquire about the judgment that you listed in your application as being reserved. Has that been handed down?
Yes, it's been handed down.
Okay, when?
Last week, Thursday.
Okay, thank you. And then just as a follow-up to a response to the question that the Premier asked you about this newly coined concept of juniority. We heard about it this morning. And your response was that one has to bear in mind that the person who's appointed as a JP of the division will have to give instructions to judges who may be senior to that person. Am I quoting you correctly?
Yes.
Yes. And then you also alluded slightly to some difficulties that may arise in those instances. And I would like you to tell us as to what do you envisage as the problems that may arise when we have that particular judge appointed as a judge president and giving instructions to judges who are senior to him. Thank you.
Look, I don't think it should be a problem, and I don't think, in all probability, it will be a problem. If, as I've said to you, we've all taken an oath. We're professional judges, and if a person gets appointed to a position and he occupies that position and he does what he's expected to do in that position, then we should behave accordingly. We're there to do a job. We're there to fulfill our constitutional mandate, and it simply won't be it would simply be wrong to not take instruction or refuse instruction. I don't think it, on a practical level, it really would be an issue.
Thank you, Commissioner Norman. Professor Mtsek.
I studied law in the 70s when it was compulsory to do Latin, Afrikaans and English in order to qualify to get a law degree. Would you agree that maybe this time, because we need to progressively introduce indigenous African languages in the courts, that indigenous African languages and indigenous African law should be made compulsory courses in the law degrees?
Yes, I don't see a problem with that. In fact, it may very well have benefits, because it exposes everyone to the culture of another, and we in this country need to understand each other. We need to understand each other's cultures and identities, and if we do that, a lot of the problems that we do have would not exist. So it would be beneficial. It can only be beneficial, especially for those practitioners who intend practicing in more rural areas like the Eastern Cape.
Don't you think, if that is the case, that the incumbent judges now could contribute to the development of the indigenous African languages if they were to start learning these languages and see how they can help develop the concepts before these languages are fully developed for utilization in the courts? And if you agree, are you learning any of these indigenous languages, or are you intending to do so in the near future?
It is not for a lack of trying. Speaking for myself, and I'm always trying to learn as much as I can. On a practical level, the problem that we have is that in the province where we are, because of our colonial history that we have, is that the language of instruction in universities is English. Most of the schools, it's English. In all the courts, it's English. So there's very little exposure given to any of the other indigenous languages. And as I understand it, the policy at the moment is that the court languages should be, or is, English.
If it can happen that you come out to be the best candidate and a second best candidate is recommended on the basis that you are the best candidate because you are a beneficiary of the privileges of the past, would you be offended?
No, I won't be. Don't think my position allowed me to do that.
Commissioner Nyambi?
Thank you. Afternoon, Judge Van Zyl.
Afternoon, Commissioner.
Commissioner Msome asked my question, so I'll ask you just one question. Given the challenges of the Eastern Cape Division, what will you consider as your weakness as a judge practicing there now?
Probably my my attention to detail, which sometimes cause me headaches and difficulties, because I expect work to be at the highest level, and that's including my own work and work from those who serve the courts. So maybe that is something that I can mention. I can't really think of anything else, and it's more a frustration for myself than for anybody else.
Thanks, President.
Colleagues, this is another candidate that I know very well. Good afternoon, Judge Van.
Good afternoon, President Meyer.
There are hardly any women judges in the Eastern Cape Division of the High Court. Yeah, more or less. Out of 28 judges, only 9 are women, and 6 of those are white. Now, when you were outlining your vision for that division, I did not hear you address this anomaly pertinently. And I'd like to find out if you have given it, this challenge, any thought at all, and if you have, what ideas do you have to change that situation?
Sorry, I didn't hear the first part, the anomaly you're referring to.
What ideas, if any, have you given any thought to the problem? Because I did not hear you mention it when you were outlining your vision. And if you have thought about it, what ideas do you have to change it?
Sorry, I didn't hear the problems part of it, President Meyer.
Shortage of women judges.
Oh, the shortage of women judges.
Women judges in that division.
Yes, yes. You know, President Meyer, we sit with a situation in the Eastern Cape, and I think if you go and look and see who were appointed, the makeup of the judges that were appointed in the last few years, you will find that I think the majority of them were in fact women, and many of those women have come here before this commission and were not appointed. We do have a problem with the pool of women practitioners that we can choose from. We do, however, and that is something that I have noticed, is that we have quite a large pool of younger attorneys and younger advocates at the different bars, who's got, to me, has shown potential for appointment. But the difficulty is that they're not there yet. They may be there in a few years' time. So that is a problem. If one identifies women with potential, then I think if they've been here and we think that they do have potential, then we need to do more in order to improve their skills and in order to bring out that potential so that they can come here and they can show that potential to the Commission and to secure their appointment. But it is something that we are conscious of, and that we are in fact trying to address. I think that is a fact.
What worries me is the fact that there is no shortage of women who are given an opportunity to act in all the states of the division. Most of them in the magistracy, they are already judicial officers.
Mm.
But for some reason, when they come here, they just don't make it.
Yes.
Now, that tells me that there is something, during their acting stints, perhaps, they don't get the support they need, but there is something goes wrong or is not done right when they are acting in those seats.
Yeah, yeah. Yes. President Meyer, the thing is, one needs to be very give thought to how you utilize acting judges. That you expose them to work where they could benefit from. In the first place, one needs to start with a person. Who is the person, and what skills and qualifications do the person have, and where are the shortcomings? What section or part of the law? A magistrate, for obvious reasons, it will be the civil part. So one needs to then take that person and expose that person to that type of work. To me, it serves no purpose in placing a magistrate who's coming from a criminal background in criminal court, because it's convenient to do so, so that you can deploy other judges in the civil courts. That judge needs to be placed in those courts. And that judge needs to be capacitated in order to perform the work in that specific court. Whether it's through appointing a mentor to that judge, which I think is something that needs to happen, that is in a position to on a daily basis to see what work is being done, what challenges the judge has, and on that basis capacitate that person to do the work. So one has to be very conscious as to how you deploy acting judges, and that is something that I would obviously look into.
You mentioned earlier that there are attorneys and advocates who clearly have potential, and you went on about that group of potential candidates, but you did not say anything about magistrates and law teachers. Would you, if you are appointed, be willing to look into those areas of the profession as well?
Yes, definitely.
As sources, as a pool?
Yes, definitely. In fact, so one of the acting judge for the last term was a magistrate. The thing is, and it comes back to, I think, one of the other questions that was put, is that there needs to be interaction with the magistracy in order to identify people that first is willing to come and who have the necessary background and skills in order to take up acting appointments. So that's the starting point as far as the magistrates are concerned. I've alluded to the fact that I think it's a good thing to bring academics onto the bench. They do bring a different angle to things, and we can benefit from that. And there are very good judges who were appointed from the ranks of the academics. In fact, when was it? Last year, we had an academic who acted in Bisha on my recommendation.
Commissioner Nkesi.
Thank you, Chief Justice. There are just few questions, and I'm making also a follow-up on this. There has been something that was of concern to me from the Eastern Cape, where you would consider candidates for acting appointments who have come to this commission to not even meet the grade. But once they go back home, you appoint again for acting appointments, even on the women. In fact, that is the position even now. What is the plan to deal with that? What is the point of keeping on appointing on an acting capacity somebody who has already shown that he cannot go any further?
Yes, no, I agree with you, Mr. Nochesi. That's what I'm saying. If a person comes to the commission and doesn't make the grade and is not appointed, but that person has got potential to be appointed, I don't see any difficulty in bringing that person back to act again, and then capacitate that person and put that person in a position to come back here and to apply again. If the person has got no potential, then I agree with you that that person, in fact, that person is occupying a position which could be occupied by another more suitable candidate who can be appointed with the necessary exposure and the necessary experience.
This morning, we have just heard that there is a judgment which has been reserved for 9 months dealing with the quantum on medical negligence. That judgment is reserved there. Are you aware of that judgment? And if you are aware about that outstanding judgment, what steps have been taken in relation to this unduly delay of delivery of judgment?
Is that a Bishop judgment,
It's
Mr.
Mthatha.
Nochesi?
It's Mthatha.
Mthatha.
Yes. Are you aware of it? And if you are aware, because I believe maybe you shared the statistics, if you are aware, are there any steps that are being taken?
Well, if any steps are being taken, it should be taken by the head of that particular court, because it seems to me to be an excessive period, especially if it's only dealing with a quantum of damages.
Now, lastly, there is a concern in the Eastern Cape, particularly in the Eastern, there's a practice, the practice of the certificate of agents. Thank you to Commissioner Mpofu here, he raised this point, where before you even launch an agent application, you first have to ask for permission from a judge who must read the certificate. He may say, no, I don't see anything on this. He just turns you back without even hearing. And in other divisions, you just move an application in the ordinary way in terms of the rule for agent application, and it is dealt with. What is your view on that practice? Would you say we must join the practice in other divisions, or we must adopt this Eastern Cape this Eastern Cape practice for uniformity? What can you say on that? Because it is subject, there are lot chances of an abuse in this process is loose.
The reason for the existence of that practice is to avoid applications being brought on an urgent basis which are not urgent. It was found that there were very many applications brought, especially after hours and over weekends and during recess, which are not urgent, and it still happens, despite the measures which have been taken. I personally think it's a good measure. It's made practitioners more aware of the fact that to make sure that your case is urgent. If it's not urgent, you are not going to be given an urgent hearing. And your opportunity, although you're not heard, your opportunity to convince the judge concerned of the urgency of the matter is in the certificate. And it's not simply a certificate as the rules require, namely that you have to certify as so-and-so that the matter is urgent and it should be enrolled in non-compliance with Rule 6, 5 or 6 of the Rules of Court. It's a certificate that requires factual allegations to set out what the urgency is, and also to make the the judge aware of what relief would be sought. And on that basis, a decision is then taken as to whether the matter is to be heard immediately or whether it's to be heard the following day or the day after, or whether service is required. It's simply a form of case management, Mr. Nochezi. I think it's a good practice, and I don't see any difficulty it being applied elsewhere.
Thank you, Chief Justice.
Thank you, Commissioner Nokesi. Commissioner Mpofu?
Thank you. Thank you. How are you, DJB?
Afternoon, Advocate Mpofu.
Thank you, Chief Justice. Excuse me. I just wanted to raise 2 or 3 quick points. The first one is, you know, this issue about the readiness or otherwise of people and the support you give them when they are acting and all that, in my view, is just solving the problem at a much later stage than it should be solved. The real issue here is that black and women practitioners in particular are not exposed to particularly commercial work because it's still a kind of preserve of a club of white practitioners. And therefore, unless we address the question of briefing patterns, you'll always be solving the problem at a point, as I put it, which is maybe too late or even irretrievable, where the damage is irretrievable. What would you do to ensure that this perennial problem of briefing patterns, particularly in relation to commercial work, which is seems to be the sole preserve of white practitioners, is broken, so that the people that you say you try them to act and you find that they are not yet there, which is true, can be there even before you call them up to act.
Yeah. Yes, may I just say, Mr. Mpofu, is that that is not really a problem which we have in the Bisho and also in the Transkei area. You'll find that the majority of the practitioners are black, the attorneys are black, and they are briefing black women to appear in the courts. So in those areas, it's not a problem. It may be more an issue that may arise in Grahamstown and in Port Elizabeth. What exactly the briefing patterns are in those areas, I can't exactly tell you, but I would assume it's exactly the same problem that you have throughout the country. I expect that to be the position. As I understand it, the bar has introduced measures in order to ensure that black women are briefed and are appearing with a senior. I don't know if it's on a sharing of a fee basis or something to that effect. I'm not sure of the details and if that is being implemented. If not, then as I've indicated to you, is that there need to be communication between the judge president and the professions for various reasons, for the case management process, in order for the smooth running of the courts, for the appointment of acting judges, identifying people who could be appointed, and that is an issue that I think could pertinently be raised with the senior members or the leaders of the respective bars as to what they have done in order to the people that they have identified to me as the judge president that could be appointed as acting judges. What have they done in order to capacitate them from their side, and in that way place pressure on them to try and change briefing patterns.
No, sorry, follow up, CJ. No, let me put it like this. I agree with you that firstly it's a national phenomenon, and and secondly, the profession obviously has a big role to play in it. That's all very well. What I'm asking you is, as it pertains to the Eastern Cape or any part thereof, do you think that the bench, more particularly somebody who's a judge president, has any role to play in solving this problem of briefing patterns? If so, what can you do? What intervention can the bench actually do, or rather make in assisting with other stakeholders, obviously, because you're quite right. I mean, the clients, there's the attorneys, and the advocates, and so on. It's not going to be resolved by one particular branch of the profession. But all I'm saying is that insofar as this is the real source of the problem of the quality of judges from which you can draw as the JP, are there any maybe let me give you an example. Here, one of the things we did to agree with you as the bar, when I was in the Johannesburg Bar Council, we introduced a rule that says that you may not have, in the bigger and complex matters, you might not have 3 white counsel. So in other words, after every time, the third counsel has to be black and preferably a black woman. So it's a professional rule. If you break it, you face a disciplinary hearing. There's no debate about it.
Yes.
And there are those who are saying it should even be reduced to 2, but we are not there yet. So that was the one thing. And then at the same time, the DJP in Pretoria has now started, because I had a discussion with him when I was chairing the Bar Council, and he said, look, this rule of yours is all very well, but what I have observed from our vantage point as the bench is that there is formalistic compliance with it. In other words, people, because they know they're going to be punished, they simply bring a junior of 1 year, and he said you can actually just see as you're sitting on the bench that this person probably has never even read the papers. They're busy filling the crossword puzzle or whatever, and they don't even have papers in front of them. So they've obviously just been drawn for compliance, and really there's no imparting of skills. As a result of that, the DJP has now introduced there's a form which you must fill if you are in that kind of matter, to actually indicate who are the practitioners in this matter, are they black or white, and women, and so on and so on. Obviously, as a kind of a subtle way to put pressure. Would you support measures like that?
Yes, I'll definitely support measures in that. I think is that not the initiative that from the heads of court in order to assess briefing patterns, that form that needs to be filled in. So that is something that's rolled out throughout the country.
Okay, good.
And as far as I know, it's also done in the Eastern Cape.
Is it done?
But on a more practical level, Mr. Mpofu, the responsibility to supply the judiciary with judges is not only the responsibility of judges to go out and look for judges. It's the responsibility of the professions.
Correct.
And it's for the professions to ensure that they take the necessary steps, that the right people get the necessary experience in order to be appointed as acting judges. And I think in one's interaction with those with the professional bodies, one needs to emphasize that and to ask them what in fact are you doing about it, and in that way put pressure on them, because it's a joint responsibility, and I think people should realize that.
No, fine. Look, okay, I don't want to belabor the point, but really what I'm getting at is that even the odd speech from somebody in your position, if you are the judge president, as the Chief Justice now and again does when he gets the opportunity, could go a long way into influencing the clients, the attorneys, to understand that this actually has an impact on the future of the judiciary.
Yes.
And,
No, I agree with
that's
you.
what I mean by I agree with you, it's a multi-stakeholder thing, but the judiciary, particularly the leadership, might have a special role. Anyway, okay, then you said something about the rationalization of the courts in the Eastern Cape, pointing out clearly that the reason why we have those 4 or 5 courts there is because of the homeland, the historical homeland,
jurisdictional
yeah.
areas. Yes.
Now, how would you go on rationalizing those courts, assuming cost was not an issue, which obviously it is? How would you re-rationalize those courts so that you undermine those homeland special planning, so to speak? If
Well,
as I say, as economists do,
yes.
all things being equal.
Yes, well, I think for a start, areas which fall historically within another area should not necessarily stay with that area if it from a practical point of view makes no sense. In other words, what I'm saying is that if an area historically formed part of a district formed part of the Transkei, it should not remain to form part if it's more practical for that area to form part of the Bishop local division. So it should be a practical arrangement. At the end of the day, we want to bring justice to the people. We want them to put a court within close vicinity of the majority of people who are the users of that court.
Okay.
So it's simply a
Yeah.
case of, on a practical level, to
Okay, no, I think that's a good
Have the
answer.
areas.
In other words, you wouldn't necessarily have to build new buildings, but you might change the jurisdiction,
Yes.
the boundaries, and so on.
Yes.
Okay, fair enough. Right. Then the last point is, and this is maybe I'm sneaking in my own personal gripe here. I appeared in the Grahamstown court in June. I've mentioned this to the acting judge president. And there was an acting judge there who was so efficient that she gave a judgment in 2 weeks. A very important matter, a big matter involving quite a large sum of money and so on, and senior counsel on both sides. And then application for leave to appeal towards the end of June. Now it's almost 4 months, and we don't have a judgment. I mean, on an application for leave to appeal, quite frankly, it's yes or no.
yes.
So how do you do the difficult job in 2 weeks, and then
Do the easy job
The easier
in
job
four-
is
not in
now
4
taking
months.
4 months past the 3 months that the
Yes.
CJA has put. Firstly, how would you stop things like that? And secondly, where should practitioners complain if such things happen?
Well, practitioners should complain to the head of the court, and the head of the court should be himself or herself should be in a position to know which judgments are outstanding if he gets the right information from the relevant employees within that particular court. And if a judgment is outstanding for longer than 3 months, the judge must be requested to give reasons for why the judgment is still outstanding, and to indicate a plan as to how the judge is planning to move forward in order to expedite the finalization of the matter.
Okay, what I'm saying is that it's obviously the fault of that judge to do that, but isn't some of the responsibility on you as the leaders of those courts to make sure that does not happen, or if it happens, at least you know about it. In other words, monitoring particularly the acting judge's work. Yeah.
Yes, Mr. Mpofu, especially with acting judges. They should be monitored more regularly than... Look, the judges are required to hand down a judgment at least within 3 months, unless there are reasons why they couldn't do so. But as far as with acting judges, one needs to monitor the position very closely, and it's something which I have been doing, because if the judge has difficulties, it needs to be addressed. Otherwise, one finds that for various reasons, person being too scared to ask for assistance, person not knowing what to do, etc., the judgment gets delayed. So with acting judges, I do on a regular basis inquire as to how they proceed with their judgments. If they have any problems with the judgments, then to discuss it with me, or I will allocate a judge with whom that acting judge can discuss the matter in order to take it to finality.
Thank you. Thank you, Mr. Chair.
Thank you, Commissioner Mpofu. Judge Van Zyl, I think I heard you say that if appointed JP, you would need about a year or two to familiarize yourself with the situation in the other courts other than Bishop, because Bishop you're already familiar with.
Yes.
Did I misunderstand you, or did I understand you correctly?
Yes, I think maybe the period that I've mentioned was too long. It could be done on a shorter basis. I'm not referring simply to the assessment, but also taking remedial action where that is required. But I think initially one will have to attend to each court and see what the difficulties are, and what action could be taken in conjunction with the head of that particular court and with the judges of that court.
See, I don't understand. All in all, including your acting stints, you were in a leadership position for about 4 years, 7 months. Acting deputy, judge president, acting deputy judge president, and now permanent deputy judge president. Why is it that you haven't familiarized yourselves with the challenges in the other courts in the Eastern Cape?
Chief Justice, maybe it's an exaggeration by saying that I have to make an assessment of each of the courts. It's simply for the future planning of the roles and how to allocate cases. The problem that we have at the moment is that we haven't got enough judges to staff all the courts because of for various reasons. Grahamstown, the motion court matters have increased to such an extent that we require more than one judge to effectively deal with those matters in a week. So it's those practical sort of issues. But as far as what is happening in the other courts, I've got a very good idea what is happening. That is clear from the statistics that we're getting. I know where there are an excessive number of partly heard matters, and I know what the difficulties are in Port Elizabeth as well.
Okay. What are the major performance-related challenges in those courts in the Eastern Cape at the High Court level? I'm starting only at the High Court level now.
I think at this stage it is criminal matters. I think for various reasons the crime rates have increased. The number of cases that we have to deal with have increased to such an extent that it really is placing a burden on the courts. And I think one must also understand the fact that we have, as I've mentioned, we've got a shortage of judges to deal with matters. So it is a case that there need to be better planning and better managing of the criminal matters. The immediate problem may be in certain of the courts that there are partly heard matters that need to be disposed of, but that can be done. I don't foresee a problem with that. It needs to be planned for, and it needs to be disposed of with the assistance of the Director of Public Prosecutions and the practitioners involved.
What exactly are problems with criminal matters except for the volume?
It is partly heard matters.
Why are there partly heard matters?
Partly heard matters, Chief Justice, has a history. As I've indicated earlier on, is that with judges being taken from one court to another court has resulted in a number of partly heard matters with regard to criminal cases, and the absence of managing those cases, to enroll cases only when they are ready to be heard.
Why is that not been done? Why are matters not enrolled only when they are ready to be heard?
Chief Justice, earlier there hasn't been any case management with regard to criminal cases. It's something that's been recently introduced. I know Judge Slangulela has started that in Mthatha and also in Port Elizabeth. That has been, but historically we sit with a backlog of basically of partly heard matters that need to be finalised. That is the only problem.
Where do you have the major problem in relation to party? I'm trying to assess what plan you have developed in anticipation of appointment.
Yes.
I'm moving from the assumption that you have scanned the environment. You also just to check whether you would be equal to, as they put it, the gravity of the position. What challenges have you picked up, and where? Where are those major challenges in relation to criminal matters? Very briefly.
Yeah, there were only two courts where there is a challenge. It's Mthatha and Port Elizabeth. Port Elizabeth has been resolved. Port Elizabeth has been resolved by a form of case management and also by judges having been allocated criminal duty for long periods of time.
I thought PE had not yet introduced case management. Has it?
Sorry, did I say that? No.
Port Elizabeth,
No,
I thought it had not yet. Yeah, I thought Grahamstown and Port Elizabeth have not yet implemented case management. They have embraced the concept and have developed some proposals, but the only two courts that have actually implemented are Bisho and Mthatha. So do I have wrong information that PE...
Port Elizabeth has, as far as criminal matters are concerned, there is a form of case management.
I don't understand. Is there case management? Is there a form of case management? What is that?
It's
in your assessment?
It's effectively assessing whether a case is ready to proceed to trial, in order to make sure that practitioners have been appointed to the accused, that they've consulted and the matter is ready to proceed, and it's then on that basis it is enrolled. So that has happened in Port Elizabeth. What hasn't happened in Port Elizabeth and in Grahamstown is case management with regard to civil matters.
So Grahamstown case manages in relation to criminal matters as well?
No.
What is the reason for the apparent resistance to the implementation of case management in Port Elizabeth and Grahamstown?
Chief Justice...
just in
yes.
preparation for the interview and also as a co-leader, so to speak, in the province.
Yes, talking about resistance, as far as the judges are concerned, decision has been taken to roll it out to those two courts. There hasn't been any resistance. So from as far as the judges are concerned, there's no problem. There might be some resistance from attorneys.
We'll get to that.
Yeah.
Let's start with the judges. When did they take the decision?
The decision, I think, was taken earlier in the year, if I'm not mistaken.
When were the norms and standards implemented? When did they kick into operation?
Yes, it was a long time before that.
Was it not the 28th of February 2013?
No, it was a long time before that.
So, what has been the problem? As a leader, what have you identified as the reason for refusing or being less enthusiastic, if there was any enthusiasm at all, in implementing what must be implemented?
Chief Justice, the position is that it was rolled out in Bisho and in East London as a pilot project. Mthatha then followed, decision that was taken by the TJP, there, Judge Slangulela, who is here. The position with regard to the other two courts is that a decision could not be taken. And as far as I'm concerned, to be honest with you, I think it was simply delayed and there was possibly not the will to take the decision.
I don't
It's a matter that was discussed at various meetings. Proposals were made. I made proposals insofar as the implementation of it, the manner in which it should be implemented, and it was dragged along for quite a long period of time.
I don't understand. I don't even understand the decision element of the answer, because when norms and standards are gazetted, they are immediately applicable to all judicial officers.
Yes.
It's not a question of, all right, do you want to decide, do you not want to decide? Whether you want to decide or not, they are binding, they apply to you.
Yes.
Why did it take 2013, 2014, 2015, 2016, 4 years, and it's only now, in 2017, that Grahamstown and Port Elizabeth are warming up to doing what they should have done as far back as 2013? What is the problem? I'm asking you as a person who may be appointed as JP, familiarized yourself with the problem. You ought to be having some kind of an answer in dealing with this problem. So why was there resistance, or maybe let's water it down to lack of enthusiasm to do what must be done?
Judge President, Chief Justice, I've taken the decision in Bisho to introduce it as the head of that court.
Yes.
It was for the head of the court in Grahamstown and for the head of the court in Port Elizabeth to take that decision. Why they have not taken a decision earlier,
You don't know.
I don't know.
Yeah.
We had several meetings about this, and we've discussed it, and we have from our side tried to explain the benefits of it,
Yes.
and it didn't happen.
Yeah. You see, I'm asking because as a person hoping to be appointed to this position, you're very much like the judicial doctor, so to speak, of the Eastern Cape. And if you don't even know the diagnosis, what injection are you going to give? What tablets are you going to dispense? That's my problem. I thought as a leader you would have worried about this situation and worked out some kind of plan, however imperfect it may be, to address this concern.
Chief Justice, I can't tell you at how many meetings we have discussed this. I can't tell you.
All right.
I've gone so far as to draft on my own accord. I've drafted a set of practice rules with regard to the implementation, which was made available to the committee who was responsible for that, for the implementation of it in Grahamstown, and it didn't happen.
Sure. How now do you give us a measure of confidence that if appointed it will happen, if you don't know what a real problem is, and you are not proffering any possible solution to the problem?
Well, Chief Justice,
can I explain in a practical sense so that it doesn't look like I'm badgering you or something? When I was Judge President, I looked at the problems not just in the Northwest but in the country, and ran workshops on case management for judges who were available and magistrates throughout the country. And I was a Judge President of a small division, which many did not have much respect for, because I was worried about the problems in the country. I identified them, they worried me, and so far as I could play some role to address them, I saw it as my responsibility to do so. I partnered with a colleague from the US, funds were available, and we were running around together. So it is in that context that I am, I was hoping that just confining it to the province that you hope to lead you would be in a position to provide some solution. But I understand your situation. What about the magistracy? What are the problems in the magistrates' courts? And how do you, serious problems in the magistrates' courts in the province, and how do you intend to tackle them?
At the last PEC meeting that we had, there were no serious problems that were identified, as far as I know. All the heads of the respective courts that were there reported on their court performances, and they were happy with the performances of their courts.
They were happy, or you were happy?
Well, short of going and seeing what's happening in those courts, one has to rely on what you are being told of by the heads of the courts.
Well,
and if they say that their performance is good, then I accept that to be the position.
Well, from time to time, including last week Thursday, I had a meeting with all the leaders of the magistrates' court in the country here in this very room. And that was subsequent to the meeting I previously had with them, and they presented their statistics to me in relation to court performance. I looked at them and said, they don't make sense. And I put questions to them. Their statistics were not satisfactory to me, the whole country. I said, you must go and redo these things. They are not right. I'm not satisfied. And I took a former magistrate, Deputy Judge President Musi, and said, come, you must now be my coordinator on this aspect, because you were a magistrate before. You know how the system works. I want you to check these statistics from the magistrates before they come to me. I'm not satisfied that the people are well served here. And the result is we now have statistics that reveal the problems at the magistrates' court level. So have you done any kind of exercise so that you can help improve performance in the Eastern Cape? Yeah, or maybe just find out from the Judge President to say, as an in-coast general overseer, what problems have you picked up? What are the major problems? Staffing problems at the judicial level, at an administrative level, accommodation challenges, and the enrollment of cases prematurely, the proper implementation of case management. Have you explored those issues?
Not beyond what is presented at those PEC meetings by the different heads of the courts,
Yes.
Chief Justice.
All right. Now, I heard you allude to a shortage of judges. I need to understand that, because it worries me when there is a shortage. But looking at the statistics now, it looks like Port Elizabeth and Bishop don't have any problem.
No.
Because there isn't a single matter that is reserved for more than
3 months.
Well, for more than 5 months.
Yes. No.
And I don't have them Tata statistics. When I inquire, they say you don't have them Tata statistics, because there is not even a single case that has been reserved, where judgment has been reserved for more than 3 months. I was only shocked to learn that, in fact, there's one that has been reserved for more than 9 months. So, how can you be asking for more judges when it looks like you are just cruising?
Well, I would agree with you, Chief Justice, that as far as Port Elizabeth is concerned, and I think also Bishop, we don't have a shortage of judges. It's more. What I have in mind is more MTATA, and simply on the criminal side.
But they don't have challenges, it looks like it, at least according to the stats they've sent me, and I believe there's no misrepresentation.
Well,
so what judges are they looking for?
Well, at the last PEC
I can tell you, Gauteng, looking at the statistics, is in dire need of more judicial capacity.
No, it may be so. It's true, Chief Justice. But in Umtata, there is a problem with criminal work. The extent of the work is such that the judges have difficulty in coping, in bringing cases to finality within the required time periods. The last PEC meeting, the Director of Public Prosecutions, they have indicated to us the nature of the cases and the cases which they still have to come forward, the number of accused and the nature of those matters. The Commissioner of Police at that very same meeting has indicated that there's a unit to deal with serious economic crimes that's going to be created in Umtata, and as we all know, those matters normally take long periods of time to finalize. So all indications are that the workload in Umtata is going to increase even further. And there are challenges.
According to direct reports on whispers you've received, they work for the full 5-day working week. There is no unofficial DS norms.
Not to my knowledge, Chief Justice.
Yes. Now, maybe I should just end with this one. You say you will instill a work ethic. I'm not too sure I understand that. What do you mean by that? Among judicial officers, among staff members, you will make sure that you instill work ethic in order to improve court performance. I'm not sure I understand that.
Well, simply to encourage staff and colleagues to do their best, to do the work as they're supposed to do, and as you're talking about a day's none and that sort of whispers that are going around, for that not to be the case, for judges to be at their stations, to do their work, and to come forward and volunteer to do work if their work is finished, for the court staff to make sure that they do what they're supposed to do. That's what I have in mind, Chief.
Well, I expect you to be more frontal about it. In your assessment of the situation and in preparation for today, did you get a picture that reveals that the work ethic is low among judges and staff members, and identify it as a problem that would require mentioning here as something that must be attended to? Are people a bit slothful or on the lazy side, and do they need encouragement to move out of what now President Donald Trump said about another low energy people, to stop being low energy people?
Chief Justice, we can always improve our work output.
No. As a leader, have you identified that there's a measure of laziness among judges and staff members?
No.
Or you can even use a softer word if you want, but I want to know whether there is that problem.
No, there is not. It's not not what you can describe as a problem. No, but as I say, it always helps to motivate and to get people to do more than what they are doing.
Okay. Let me disclose that I've asked you more questions than I asked your colleague Judge Mbelenga, because he took almost the whole hour before we could even ask, explaining, and he even put questions to himself and answered them. So don't think that you were unfairly asked more questions than another candidate. I just needed the answers to questions that you did not volunteer.
Yes, I understand. Thank you, Chief Justice.
Thank you very much for making yourself available, Mr.
Thank you.
Van Zyl. You're excused now.
Thank you.
Thank you. I think it's time now for the room to be cleared.